We're going to start talking about specific crimes now going forward to the rest of the semester, and we are going to start with homicide. So what is homicide? Well, first let's give a little background, and this is general information. We're going to break that both murder down and manslaughter down. But what is homicide? At common law, unjustified and unexcused killing of a human being. Nice and sweet, right? It's an unjustified and unexcused killing of a human being. Most of the jurisdictions in America divide homicide into two categories, murder and manslaughter. And then each of these categories are divided to reflect differences in available punishments, okay? And I think I had mentioned this before, but in New York, we have over 50 different laws relating to the death of a human being. I think there's 59, 59. Murder first, in the first degree, is the highest level of murder, and it can result in a punishment of execution, depending on where you are in this country. And then there's everything else that is murder in the second degree, and the harshest sentence you can get is life without parole. And then we have manslaughter, and this is viewed as a less serious killing. And manslaughter is divided into voluntary and involuntary, and these are not punishable by execution, and very well can be punished by incarceration. And depending on what category you're in, there's sometimes you do not get incarceration. So what's the determinant factor in all of these? It's going to turn on the actor's criminal intent. Okay, that mens rea is going to determine whether we're going to be talking about murder 1, murder 2, voluntary manslaughter, involuntary manslaughter. Okay? So common law defines homicide as the unjustified and unexcused killing of a human being. Modern times, criminal homicide is going to be defined by these elements set forth in the statutes. And I'm going to have you, in one of the assignments here is when we are done, I'm going to have you pick one of those 50 some odd homicide statutes from New York and dissect it. So what do we need? Let's kind of break this down a little bit further. What do we need? We need a human being, right? We need what is a human being. Makes sense, right? The unjustified and unexcused killing of a human being. But what is a human being? Under common law, it's kind of self-evident. Born alive, right? Under the Model Penal Code, a person who has been born and is alive. And nowadays we have modern technology that kind of gives us some questions about when the beginning and end points of life are on the spectrum. And we have this question regarding a fetus. Can you murder a fetus? When does life begin? There was a man, 1970 case, pre-Roe v. Wade. Man purposely kicked former wife whom he knew was pregnant in the stomach, threatening to stomp it out of her. And the fetus died. He was charged with homicide. And the court said, no, fetus is not a human being. In 1984, a woman delivered a baby into a toilet bowl where it drowned. And the woman was charged with murder. The woman testified that the baby did not cry and that she did not tie its umbilical cord. So therefore it wasn't a human being. And the court in that case said, yes, the fetus became a human being after the child passed through the birth canal and took a breath. It is irrelevant that the baby may have been dead by the time the process was finished. In response to cases like this, legislators either created or amended statutes to broaden this definition of human being. And California was the first, and many states thereafter followed suit, and the federal government. So the federal laws consider an embryo a fetus from the time of conception. Others determine that a fetus is formed when the child is able to move within the womb, 4 to 5 months. And I will say, just after the passing of the California law, Scott Peterson was convicted of killing his pregnant wife, murder one, and the fetus. It was charged separately, and murder two for the fetus. And that was the first case out of the state of California right after the passing of that law. Few states don't recognize a fetus as a victim, and few states will say that a fetus is a victim once it is viable and can survive outside the womb. So we have various definitions there in what's considered a human being. What about a mother who has an abortion in California? Abortion's not included in, it has its own separate statute, and it's the exemption in state, because abortion's legal. Roe v. Wade made abortion legal. Depending on where you are in the country or what state is going to be dependent on at what point you cannot have an abortion, but states cannot ban abortion straight across the board. So abortion is not included in the homicide statute. It's actually specifically a specific exemption. I want to show you this. This is New York law, and this is current New York law. You can pull this up in the statutes and read these definitions. And under the penal code, I gave you the section number, it says the killing of an unborn child after 24 weeks of pregnancy is homicide. Okay, so New York recognizes a fetus after 24 weeks as a human being for a definition of homicide. But check out the next chart. It's actually the next one in line. They go right after each other. 125, 125.5. It says a person that is a victim of a homicide is defined as a human being who has been born and is alive. Do you see any discrepancy here? Do they conflict with each other? It's just an interesting, and sometimes we have laws that kind of come into play like this. I mean, this 120, I guess my argument would be 120.05 already is a somebody here. And then an unborn child after 24, maybe the two in quotes is a different entity, so to speak, or a different object or identity. So I just thought that was interesting and wanted to share with you. So we talked about birth. Now we got to talk about the other end of the spectrum, right? When does life end? Was the victim dead before the defendant acted? In the past, the common law, death was assessed practically when the human being ceases to exist once the heart stops functioning. So when the heart stops, under the common law, you were dead. The modern view is brain dead. And there's various definitions as to what constitutes brain dead, because you know that due to technology, we can live longer. New York defines death as irreversible cessation of heartbeat and respiration, or when these functions are maintained solely by extraordinary mechanical means and is irreversible. No more functioning of the brain, including the brain stem. So that's what defines death here in New York. There's no going back. There's no going back. You don't have a heartbeat, you're not breathing, or if you're hooked up to some machine that is allowing your heart to beat and respiration. But if those were to go away, you would cease living. So the question now becomes, what happens if a victim of assault doesn't die right away? Due to technology, we can stay alive longer. We can be saved. What happens if the victim survives months, a year, year and a half. Is there a time frame on this? Under the common law, a year and 1 day. If you were a victim of an assault and you were in the hospital and you were in a coma for 1 year and you pass away on day 365, the person who assaulted you can be charged with murder. But if you are in a hospital in a coma for a year and 3 days and you die of your wounds, not murder. What do you think about that time frame? Nowadays, we could certainly live a lot longer with technology. The more modern view is, what if it was regardless of the situation, the argument for the time frame is, did they die some other way, or but for the defendant's act? Okay, they wouldn't have been in this situation. But for the defendant's act, they wouldn't have been in this situation. So let me give you an example. In the hospital, you've just been assaulted, you're in a coma, and you catch some sort of infection, and you die from the infection. Can the defendant be charged with murder? And under the modern view, the answer is yes, because but for the defendant's act, you would not have been in that situation. So there is no time frame. You can be in a coma for 3 years and die 3 years, the assault victim. And that person that put you or assaulted you could be charged with homicide, even after they are convicted of assault, right? Charged with assault, you're in the hospital, and 3 years in a coma. 3 years later, you pass away. Oh, there can be a charge for murder now, not just assault. All right, let's talk about suicide. Is suicide a crime? Under common law, it was a crime, but then that begs the question of, how did they prosecute, right? How do you prosecute someone who took their own lives? What happened was they took their land. So if you committed suicide under the common law way back in the day, the state or the government would come in and take your land. It's not a crime now. But the question is, what if you help someone commit suicide? Or as they say, assisted suicide? Is it homicide? This is going to vary from state to state. This is a state rule. But states can prosecute, if there's no exception for assisted suicide, states can prosecute you for murder, for helping somebody commit suicide. The Supreme Court has held that statutes prosecuting for assisted suicide is constitutional. Who does this really target? Doctors, right? There are some exceptions that merely allow for terminally ill patients to end their lives with a physician's help. But the majority of states will prosecute. There might be a lesser penalty involved. The model penal code, a person who purposely aids or solicits another to commit suicide is guilty of a felony of the 2nd degree if his conduct causes such suicide or an attempted suicide. New York State, 3 years ago now, 2017, our highest court, the Court of Appeals, way up top, if you remember our ladder from our discussions at the beginning of the class, the highest court in New York State ruled that doctor-assisted suicide is illegal in New York State. So we do not have any form of exception for assisted suicide here in New York. So, without further ado, we're going to talk about the elements of murder. Murder. What elements do we need? We need a criminal act. We need criminal intent. we are going to need causation and harm. This is a specific consequence crime, specific crime, consequence, result crime, where the district attorney has to prove that the defendant caused the harm. This is one of those. Criminal act, let's start with that. That's pretty straightforward. You need a voluntary conduct that caused death. What kind of conduct? Whatever pops in your head. Think about it. Shooting somebody, trying to run someone down with your vehicle, putting poison in their drink, punching them very hard in the face, which could potentially cause death, which maybe they bang their head. You use some sort of dangerous instrument. You choke somebody to death. You set up a trap if somebody's to open your door in your dorm room and a bow and arrow goes off to keep trespassers from coming in and they get hit with an arrow. Okay? Criminal act, voluntary conduct that caused death. We need an act. But now we need, and this is where things get a little sticky, criminal intent. And we're going to spend a lot of time on criminal intent. At common law, there was no degrees of killing. First degree, second degree, no degrees. Killing was defined as, or murder was defined as killing with malice aforethought. There's a pretense. It's calculated. So it's an intentional, pre-planned, deliberate killing motivated by ill will toward the victim. Okay, so it was limited towards the calculated killings at the get-go, way back in the common law. So you had to plan it out to kill someone, calculate it, and you had to have ill will towards your victim. This has been redefined in the common law over time to not only, they took away the calculation, but it also included, you still needed malice. You just take out the calculation portion. We're going to talk about what malice means in a minute. And it added extreme reckless or wanton conduct. Okay, so this eliminates the no longer required ill will. Okay, this was developed was a killing if you didn't intend to kill. This is where this stems from, this recreation or this redefining of the definition, is if you didn't kill but nevertheless acted in a way that you knew created a high risk of death and you didn't care about it. That's what this means. Reckless or wanting conduct. You create a high degree of risk of death and you don't give a crap. When you shoot a gun into a crowded train, you intend to shoot the gun. You may not intend to kill anybody, but seriously, reckless. Isn't that reckless? And you don't care. I'm just going to shoot my gun. There's people around. If I shoot someone, I shoot someone. That's what that means. Extreme reckless and wanton conduct. And that can get you charged with murder under the common law. Remember, there's no degrees. Two things I want to point out here. And I'm going to go into some examples in a moment. My key here to this reckless component, you don't intend but act in a way that you know creates a high risk of death and not caring. It's kind of an implied malice. And I just gave you that example of shooting a gun into a crowded train. You know the risk of shooting a gun into a crowded train, but you do it anyway. And you act with, and we're going to use this phrase often when we're talking about reckless as the mental state or the mens rea with regards to murder as we go forward. Depraved heart. You act with a depraved heart. It means you don't care. You don't care. All right, let's do an example. Defendant, a juvenile, put one bullet in a 5-chamber gun. According to his testimony, he did not expect the bullet to discharge until the 5th pull of the trigger. He then pretended, quote unquote, pretended to play Russian roulette with Billy, a 13-year-old friend. There was no evidence that he spun the chamber, but on the third pull of the trigger, the gun fired, killing Billy. And that young juvenile is charged with murder. What do you think? It's like, I did not intend to kill Billy. I didn't anticipate the risk because it was going to fire at round 5, not at round 3. What do you think? What are the chances of the gun firing on the third pull? He pulled twice, nothing. Third, assuming there was no spinning after each pull, that's like a 30, was it on the third spin, 33%? Did he create a risk of death? I hope you're shaking your head yes, because anyone, especially a juvenile who's pulling a gun out when there's other people around, creates a risk of death. Conscious disregard for that risk. There was no reason to create this risk at all, right? The chances, his claim of like, what are the chances? I meant to do it, is irrelevant. He knew the risk, completely disregarded that risk, and he didn't care. So this would be an example of murder under the common law. There's no degrees. Under the reckless theory, okay? The extreme, acted with extreme reckless and wanton conduct, okay? We're going to talk about malice a little further. I want to talk about the Model Penal Code. They define murder intent. We're talking about criminal intent. They define the murder intent as purposely, knowingly, or recklessly under the circumstances manifesting extreme indifference to the value of human life, okay? There's an exception to this element for felony murder. I'll get to it in a second. But these three things exist, okay? To have malice. You intend to kill, intends to cause serious bodily harm, and a depraved heart, okay? Defendant intends to kill the victim. Defendant intends to cause seriously bodily harm. Defendant has a depraved heart, meaning immoral, wicked, does not care if victim lives or dies. Okay, the malice component is defined. We're going to go through more examples here in a second. When does it exist? I hate you, you annoy me. No, you need the desire to have the victim dead, or you're indifferent to whether the victim lives one way or the other. Model Penal Code, I just read you the definition. I just had my slides flip-flopped. You need purposely, knowingly, or recklessly. Those three things, okay? Under the circumstances manifesting extreme indifference to value of human life. There is an exception to something called felony murder. We will cover that at the end of our discussions here, probably the next video. But if we have murder, we have those three things, okay? Let's go through some more examples. I think we may have talked about some of these already. Mark, Jay, and Tom have an obsession with guns. One day while out target shooting, Tom arrives with his brand new bulletproof vest, not vet, vest, he bought on a top grade military gear website. He wants to try it out. Tom asks Mark to shoot him in the chest while he is wearing the vest. Mark agrees. Jay protests and goes inside. Tom stands about 10 feet from Mark. Mark raises his arm with his 9mm and shoots at Tom. Tom falls to the ground and doesn't move. Mark missed the chest completely and hit Tom in the head, and Tom died instantly. What do you think about this one? Prosecutors want to charge Tom murder under the common law. We're not talking about degrees yet. We'll get there. We're talking about those three levels. Did he intend to kill Mark? Did he intend to cause serious bodily harm? Did he act with a depraved heart, does not care if his victim lives or dies, immoral, wicked, Extreme difference. Did he act manifesting extreme indifference to the value of human life? Is this like the train? Shooting a gun in a crowded train station where there's people? But Mark asked him to do it. Does he have a defense there? I think we talked about this example under consent, right? In this instance, you cannot, we already talked about relative to consent. There is no defense here because there's no defense when you're dealing with something that can cause serious injury or death to somebody, okay? So Mark can be charged. Can he be charged with murder? In this example, yes. This is reckless, right? He knew he's playing. When you come to the game with a gun, you're already creating a risk of death. Show up with a loaded gun anywhere, you're creating the risk of death. Does he not care whether his victim lives or dies? Is he indifferent? The prosecutor will show that he was, otherwise he wouldn't be shooting at somebody, whether or not he was aiming at the vest. Anybody who cares about somebody would say, oh, but what if I miss? That's what the prosecution will argue. Tom might argue something differently. But in this case, I think we got reckless. And I think the prosecutor has a good case for murder. How about Karen learns that her worst enemy, Rick, is coming to town in 2 days. She buys a gun and decides to kill Rick as he steps off the train. 2 days later, she takes the gun with her to the station, loads it there, and walks up to Rick and shoots him at point blank range in the head. It should be head. God, I have lots of typos. Head 5 times, killing him instantly. Now, we all should be shaking her head. Yes, that's our version of premeditated right there. Planned out. And she has malice. She has number 1 element, the first example of the 3. Okay? Defendant intends to kill the victim. So the question is, how does the prosecutor prove intent? How do we know one's intent? In the common law, defendants were not allowed to testify. Well, I should say in the early 19th century. They were not allowed to testify. They couldn't come and say their piece. Now they have a constitutional right. Now they can, but they can't be compelled to testify. The prosecutor can't put them on the stand. That's their own right to decide whether they want to testify. Prosecutors can't say, I'm going to call the defendant to the stand. Can't happen. So how do we know? Not like the defendant, unless the defendant confesses, yeah, I intend to shoot him. Unless Karen says, yeah, I intended to kill Rick. We talked about this with evidence. The presumption is based on the act itself. The presumption stands when there is a deadly weapon. Okay, so we have 1, a person is presumed. Remember our inferences that a trier of fact can consider. A person is presumed to intend the natural and probable causes of his act. I didn't know that that was going to happen, i.e. killing people when I shot a gun in the train station. That act of shooting is presumed that the defendant knew or intended that the natural and probable causes of his act would occur. It's presumed. Number 2, a killing committed with a deadly weapon is presumed to have been committed with malice. Those are our 2 presumptions. These are the 2 things that have to be considered. Remember our difference between inferences and presumptions? The defendant is presumed innocent until proven guilty, whether also presumed their intent is presumed based on one's act to intend the natural and probable causes of that act. Okay? If I drive down the roads in a 30-mile-an-hour zone at 100 and I run over a child, the presumption is that based on my act of speeding, I intend that a natural and probable cause of that act, I could run somebody over. That's presumed. Deadly weapon, well, a vehicle can be a deadly weapon. So the presumption is, if I'm using a deadly weapon, I'm doing it with malice. Of course, that can always be rebutted. I didn't mean to do, maybe the brake pedal didn't work, or the gas pedal got stuck to the floor and I couldn't stop. It could be overcome, the presumption, but you have to understand going in, these things are presumed as equally as the defendant's presumption of innocence. It's presumed. Okay? So we had our criminal act, criminal intent. We're going to move on to the causation and harm for murder. Oh, one more note on the deadly weapon component of presumed. A killing committed with a deadly weapon will be presumed to have been committed with malice. In statute, some states, actually I would imagine all of the states in the federal government will have a definition of what constitutes a deadly weapon. But again, the list wouldn't be exhaustive. If I came at you with a bat, my intent was to break your leg, but for whatever reason I'm a terrible shot and I hit you in the head, the bat is going to be deemed a deadly weapon, and that the presumption is that I presume to have committed that crime with malice. Okay? So now we'll move on to causation. This always exists, right? Because this is a results crime. You must have to show, the prosecution must prove causation, basically that the defendant caused the death. And remember our factual and legal cause, the but for the defendant speeding down the road, the child wouldn't have been run over. And is it the legal cause? Remember, is it reasonably foreseeable? That's the test that an objective person has to look at in those circumstances. Was that reasonably foreseeable? Yeah, when you go speeding down the street, it's reasonably foreseeable that you can run over a pedestrian. So that's how our causation works, right? And then death, the harm. Did I cause the harm? Well, if we have a dead body, then we have the harm. So we have murder. And and this death is defined by statute, and we already talked about it at the beginning. I won't relive it here. Now, one more point I want to discuss relative to murder, and then we are going to switch. This is under our common law and model penal code, and then we are going to switch to talking about the degrees, because when you have a state like New York who has 50 some odd charges, they have to be distinguished in degrees and grades. So we're going to split up murder and talk about it as murder 1 and murder 2. But first, I want to talk about defenses. Are there any defenses to murder? When we talked about this in Chapter 5 and Chapter 6, when we talked about a defendant's defenses, some of the examples were cases involving murder. What's the first one that pops in your head? Justification. Self-defense. Right? Stand your ground. How about, the deadly force by police was justified. So defense of others, right? Defense of property. Not real property. You can't use deadly force. Just kind of doing a little recap. You can if you are protecting your castle, your home, but there has to be certain conditions that are met. So we have justification. We have a defense under justification. We have a few under justification. And we have a defense under excuse. Remember, excuse takes into account the defendant. Justification takes into account the actual defendant's act. What do we have? Insanity. All right, so that covers our snapshot of murder and the elements. We're going to break it down into degrees next.